Our agenda today is to start first with a regulatory update, followed by lawsuit velocity, notable cases and key learnings from those, as well as some takeaways, and then, as I mentioned, your questions and answers. But to get started with our introductions, I'll first introduce myself, Corb O'Connor, Director of Accessibility Advocacy at Level Access. Been working in the field for the better part of the last dozen years, and have done everything from development and code, content, all the way through to program management. And so had a little bit of a hand in so many different parts of what we're doing, and really seen how the advocacy of grassroots organizations has really shaped the regulatory and the legal landscape that we're going to be talking about today. I'm excited to be joined by Eve Hill, partner at Brown Goldstein and Levy. Eve?
Hello, I'm happy to be here. I'm a disability rights lawyer and consultant. So I've been practicing disability rights advocacy for 30 years or so. I try both to litigate when covered entities are recalcitrant and help them when they're not. So these are the two ways that I try to bring accessibility into the world. I work a lot for the National Federation of the Blind and am their general counsel. And so I do a lot of work in the digital accessibility space, as well as in higher education and other areas that are heavily affected by digital accessibility.
Excellent. And so I think we're going to kick things off then with a look at the regulatory update. Eve's going to start us off with that.
So regulatorily, U.S. regulations are getting more specific about disability rights and web accessibility. So we've seen the Justice Department publish a final rule under the Americans with Disabilities Act Title II, which covers state and local governments and their vendors, basically. They won't directly affect the vendors, but state and local governments now have clear obligations to make sure that their websites and mobile apps are accessible, and they're going to have to pass those obligations on to their vendors. The standard for compliance now is not just effective communication. The ADA Title II has always said that state and local governments had to provide equally effective communication with people with disabilities. And now they've set the standard for web accessibility specifically at the Web Content Accessibility Guidelines, or WCAG, 2.1, level A and level AA. So that's a more providing more specificity. It also has deadlines, but the deadline is 2 years, or April 2026, for entities whose population is at or above 50,000 people. And for entities whose population is below 50,000, they get an extra year, and their deadline is April of 2027, as well as special districts are also governed by the later deadline. And at the same time, the Department of Health and Human Services released a new regulation under Section 504 of the Rehabilitation Act. That affects entities that get any kind of federal funding, which includes most colleges and universities in the country. It also covers social service organizations that get federal funding. So it's a lot of healthcare and a lot of social service organizations, but also a lot of higher education. And that will affect their vendors too. So this sets a compliance standard, not surprisingly, of the Web Content Accessibility Guidelines 2.1, level A and AA, same as the Title II standard. So we can see where this is going. And the deadlines here are set based on how many employees the covered entity has. If you have 15 or more employees, the deadline is May 2026. And if you have less than 15 employees the deadline is May 2027. Now, both the Section 504 and the Title II regulations on web accessibility and mobile accessibility have some exceptions. So archived content doesn't have to be made accessible unless and until someone requests it specifically. Pre-existing conventional electronic documents, those are Word documents, PDFs, those kinds of things, don't have to be made accessible unless they're currently used to access the state or local government entities' programs and services. Then they do have to be accessible. Pre-existing social media content doesn't have to be accessible. and password protected conventional electronic documents that are specific to an individual or account. So for example, your gas bill, if it's put out by your utility bill from your state or local government entity, that if it's password protected and specific to you, doesn't have to be made accessible unless and until you request accessibility. Finally, content posted by third parties, either individuals or organizations, is exempted unless the state or local government has contracted, licensed, or otherwise arranged for it to be provided. Corb, you want to talk about states?
Yeah, so we've got several states that are really starting to double down on digital accessibility. So starting most notably with California. So there is a bill in the California legislature that gets some activity and then gets quiet for a little while and comes back and gets, but most notably that AB 1757, as it was currently named in this past session, is really an attempt to hold third-party vendors accountable. So really to say that even an agency that builds a website has some liability for that accessibility. And so they could be held liable. This comes back in 2018, 2019, there was a lot of money spent to build a campground website in California to the tune of about $60 million that was not accessible. And so this is an attempt, I think, in a reaction to instances like that. But we've seen this too in other states. And that is next after this one would be in Colorado. So we've seen Colorado's really been leading the way in accessibility at the state level, and really looking at making sure that they're at a state procuring accessible technology. They're asking questions of their vendors, and then more importantly than just asking at the time of renewal or of contracting, they're really following up and making sure that vendors are continuing to do what they should be to make things accessible. And then the other one worth highlighting today is in the state of Maryland. Maryland has introduced a new law that took effect this year that's really saying to K-12 institutions, you have to purchase accessible technology. And if you don't, because you can't find it or it's not on the market, there is an approval process to get an exception. That exception process is difficult, intentionally difficult. It's requiring that everybody have visibility to what's happening. And more importantly, what are you going to do when a student or a parent needs access and the tool that you're choosing to use at a district level is not accessible? And so really that law, I think, goes a step further than we've seen in so many others, where instead of just, and one that we would suggest even to you and in the private sector, that instead of just saying we have an exception process, making sure that once granted, what are we going to do with that exception and how are we going to make sure people can still use the technology that we've built? On the international front.
Moving to the international front.
Yeah, so on the international front, we saw in Europe for a long time was that there was diverging accessibility laws and that experiences across the European Union. And so in April 2019, the European Accessibility Act was adopted by the Parliament and the Council in Europe. And really what that set out to do for those 27 member states is that they had to pass their own versions of the EAA, could be stricter, could be have more requirements, have more penalties, but they had to have a minimum standard. And that had to be passed into their state law by 2022. Now, most of them have done that. Those that haven't got sanctioned by the EU. But what we expect is that, a lot of these states now are figuring out how are they going to be enforcing this new law. That widespread enforcement is beginning next June. And then by 2030, organizations must complete, reporting reviews to ensure that ongoing compliance every 5 years. So what's covered by the European Union Accessibility Act, the EAA, as we call it, is really a kind of in some ways a very specific list and in other ways vague. And it's really meant to be about commerce, and it's meant to be about those areas of life that impact private citizens. And so really looking at, for example, computers, smartphones, operating systems, ATMs, ticketing and check-in machines, digital TVs, phone services, passenger transportation. So that's, bus, rail, air, water, banking services, ebooks, and then most notably e-commerce, and pretty wide category of e-commerce. And our understanding of that has, in most of the states, has been that let's talk about where somebody is doing commerce. If they're doing it on your website, the EAA is intended to cover you. It's really meant to cover that business to consumer arm of the economy. So regardless of where you're based, just like we saw with the GDPR, the Global Data Privacy Regulation, it's really going to affect organizations around the world. And so US companies that are doing business in Europe need to be mindful of the EAA and its penalties. Now here, slight different standard that's applied to your technology, and that's this EN 301549 standard. Takes WCAG and expands it and makes it much more concrete for things that are physical devices, that are mobile apps. Remember, the bulk of the web content accessibility guidelines was written before we had mobile phones and mobile apps. Now that's changed. Now that we have WCAG 2.1, we have 2.2, but this 301549 is set to be a real technical standard that really applied it quite clearly. Coming back across the ocean from Europe, we have the Accessible Canada Act and the Accessibility for Ontarians with Disabilities Act. So both laws really setting those clear technical standards for digital accessibility, again, affecting US companies doing business in Canada. So on the AODA is the one that most folks know about. It was a first provincial law to force an accessibility standard and reporting requirement. And so this one really applied to private sector companies with more than 20 employees. And then, of course, all public sector organizations. And so they need to report every 3 years, starting last year. By the way, if you didn't file your report, it's still due. It's like taxes in the US, right? You still have to file it even if you forgot. There's some penalties, but it's better to file than to wait. And so really the non-compliance penalty there is sizable. It's 100,000 per day. And could have fines for individual directors of those organizations too. So the Accessible Canada Act likewise is affecting organizations based on employee size. They have an employee size of more than 10, and then their reporting requirements are already live as well. So after only 6 months of deliberation, and then 1 year after it was introduced, this ACA came into effect in July 2018. And what's notable about this to me is that they've really taken the definition of barrier and made that the focus of their legislation. It's not, certainly web content is important, following a standard is important, but really it's the idea of what is a barrier? Well, a barrier has a very technical definition, of course, but it's meant to be something that's really wide ranging because they want to be barrier free by 2040 for all folks with disabilities. And so they've taken a very open view of, for someone who, not just with blindness or low vision or navigates with a keyboard, but maybe learns differently or processes differently, is all covered by this. And as I mentioned, this 3-year reporting process. And interestingly here, there's this idea that you report the first year on what's your plan and what's your feedback mechanism for folks with disabilities. And then you do progress reports for years 2 and 3, and then rinse, wash, repeat. So really about focused on that continued reporting. But here in the US, we've had the lawsuits and their velocity. And Eve, I'll let you talk about that part.
Well, we have not slowed down at all in terms of accessibility lawsuits, in particular in the web and mobile app space. We have continued to face, there continue to be a tremendous number of websites in the world and a tremendous number of inaccessible websites in the world. And therefore, there are a tremendous number of lawsuits challenging the inaccessibility of those websites.
And what we've seen too is that, a lot of companies are looking at this and they're coming to us and they're saying, how do I need to be accessible so I can stop these lawsuits from coming? And really, because of the number of these cases that are out there, remember, these are just the lawsuits. These aren't the complaints that you receive pre-lawsuit. And so the absence or presence of these complaints isn't a great barometer of how accessible you are. It's really about making sure that, these lawsuits are really looking at basics, alt text, color contrast, keyboard focus, form labels, link text, all things that are sort of table stakes for accessibility. And the Department of Justice has said that the ADA has covered websites since 1996, and yet we're still finding that these specific industries are becoming targets for action.
And it's not the hard stuff; it's the easy stuff that they're not getting done.
Absolutely. And it continues to amaze me. I remember that I looked at the Target settlement a few weeks ago, and we were talking then about alternative text in 2006. We're still talking about alternative text as the
Alternative
number
text.
one problem.
And PDF tagging.
And we're seeing that, still in the retail industry. As I mentioned, started with Target, but people are still struggling to achieve compliance, and they're really finding themselves at Target. And we think that's probably because the sites frequently change. And so the thought that if I go to you and as a complainant and say, I had trouble because you didn't have labeled images, well, you probably have them somewhere on your site, right? They're also really easy to find, the top retailers out there. Higher education as well, right? So there's this legal imperative for all schools, not just the big ones. That's of course connected with the Title II of the Americans with Disabilities Act, because so many of these are owned and operated by state and local governments. As well
Section 504 covers a lot of them. So that
absolutely.
HHS regs at play as well.
And so, we're seeing no industry really immune. That, could be cannabis to pet supplies and probably everything in between. So, and we did some research this past year, some of our proprietary data. We found that plaintiffs are really strategically choosing states to file in. So, and of course, your exposure expands beyond just the states where you are based. We saw in this map we have on screen here of the states that are kind of broken into 3 tiers. So the first tier of New York and Florida. Now, New York, there's 3 state laws on human and civil rights. Three laws, I should say. 1 is in the city, 2 in the state. Human and civil rights laws. There's monetary damages available for some of these cases, which of course makes them interesting for plaintiff attorneys. But because of that, we talked about that blanket way that people are complaining about suits. Really, there's this thought in the Southeastern District of New York is starting to push that you need to be more specific. You can't just, I remember Lainey Feingold quoted it for us once at a conference saying, if you're going to live by the photocopier, you're going to die by the photocopier, was the way one judge put it. Florida, of course, big firm that files a lot of cases located there. Pennsylvania has this wide definition of pain and suffering that may be playing into that. Minnesota, simple as a law firm based here in Minnesota. And then Illinois has a civil rights law since 2007 that's really focused on IT procurement. And California, slipped, used to be number 1, now down to number 4. But
I think people are filing in state court there.
Absolutely. And there was some talk too of the way that the Unruh Act was kind of had changed its definition over time as well, that may be contributing to some of that, where you could seek those monetary damages.
All right, we have some emerging trends. We're not just talking about websites and mobile apps anymore. We're talking about kiosks. Everywhere now has an entry kiosk where you no longer talk to a receptionist, you now talk to a machine. And those are being rolled out at a rapid clip, and accessibility is not being taken into account. So we've actually had a couple of lawsuits challenging web kiosk accessibility, and those have been successful for the plaintiffs. So be prepared to get your kiosks in order. We've also worked with. They love when I work with them. Social Security, about having rolled out inaccessible kiosks, which have all but 3 been replaced now. So kiosks are going to be a continuing issue. And then employment software. This is where the software that you use for your job is no longer accessible. It's happened a lot in the medical field as we've switched to electronic health records, that things that used to be able to be done by a blind person are now, because they're using inaccessible software, they're now not able to be done. We're seeing a lot of this also in the customer service area, where customer service is entirely mechanized, digitized. And that's making, when the websites are not accessible, or when the customer service software that's being used by these customer service agents is not accessible, that's keeping people with disabilities from having those jobs. And so we're seeing cases being brought to the EEOC about employers' failure to buy or use accessible software. And they're not getting away with the whole idea that, well, I'll just accommodate around it. Because number 1, it's not that easy to accommodate around something that is so enmeshed in what you do. it ends up being you paying for a second person to help do the job. And who wants to do that? So it's really important for employers, not just web companies who are selling their goods and services on the web, but employers to be checking on the accessibility of the software that they're buying to use with their employees. And so that's going to be a big deal coming up. And then AI is rolling out everywhere, and we've got accessibility concerns about that, particularly in the hiring space, where AI is being used to screen out applicants from jobs. And there are a couple of problems, potential problems with AI. Number one, it may discriminate on the basis of disability because it's learning, the data on which it learns doesn't include much about people with disabilities. So you have to force feed it more information so it'll respond appropriately and not weed people with disabilities out. And then the accessibility and the discriminatory assumptions that sometimes go into the AI. So a lot of times things that are reading your facial expressions to tell whether you're an honorable, honest person. Those are discriminating against a variety of people with disabilities who may not maintain eye contact with a camera. That's not even a human. So people with neurodivergence, people with blindness, a variety of people are being screened out or being kept out by the inaccessibility of AI screening tools.
And on the topic of AI, I always find it interesting sitting down talking to somebody and they say, well, AI is going to make your life so much better as a blind person because you're just going to, instead of shopping and scrolling through all these inaccessible pages, you just get to ask questions. And I think anybody who has talked to a smart speaker in their home knows how annoying it can be. But even still, these interfaces, to your point, Eve, are, I have a text field usually at the bottom, the content's above it. So from a very basic perspective, to interact with this, I'm always reading the AI response backwards. So little things.
Right, exactly. So what makes you a target? Some of the things, so I'm not talking about click-buy lawsuits, but in general, what makes you a target is your importance to people's lives. How important are you? How big an issue is this in someone's life? Do they really need to get to whatever it is that you're selling, whatever information you're providing, whatever services you have available? So importance to people's lives raises your visibility, raises your importance, makes you more likely to be someone that gets challenged for excluding people because of inaccessibility. Similarly, your ubiquitousness. If you've cornered the market, you're the only one. You really better be accessible because we're going to have to come after you because we have to use you. And whether you have accessible competitors, in some ways, if you have accessible competitors, you may get off the hook a little easier because I can go buy my stuff from them. You're losing business, which doesn't seem like a good business approach. But if you have accessible competitors, you may be able to escape for longer. If you have deep pockets, again, some lawyers are looking at whether you're going to be able to pay the fees and get the job done. Those are important reasons you could become a target. Employment potential, are you a big industry? Are you a customer service industry? Are you health records, health industry? These are big industries with big employment potential for people with disabilities, especially when you have, for example, work at home jobs, where transportation is a huge barrier to people with disabilities, and avoiding that barrier can really make an inaccessible employer a target because people really need and want these jobs. The location of your web presence, of course, if you're located where people are looking for you, it can be anywhere. If you're located in New York, you're more of a target, but your website is located everywhere. So you have to be careful and aware of where you're providing your website. And then when you got a demand letter, what was your response? Most of us will give you an opportunity to resolve the issue without going further in the litigation process. And if you took advantage of that opportunity, you're in a much better position to get a resolution where you have some control over how and when you fix the problem. It's not like you get to get out of fixing the problem, but you do get to set more of a timeline or have more say in what the timeline is for fixing the problem. And that keeps fees down, it keeps everything down. So demand letter response is really important. And then the outrageousness of the violation. Am I going to be able to say to a court, this is outrageous? If it is, then you really need to get those things fixed right away. So the hypocrisy is often one of the things that I look for in looking at who's going to get sued.
So we'll turn next to some of the notable cases, and more important than the facts of each case are the learnings that we've got from each of them. And so we'll start with the one that may not immediately seem like something that applies to digital accessibility, and that is this idea of the Chevron deference that you've probably heard a lot in the news about in late June, early July. But this idea that, there's a lot of ambiguity in law, and so the thought of the Chevron deference was that Congress gave the agencies gave them more power to really work out the specifics and the details of these various ways that we needed to regulate industry. But Eve, I hear that changed with this case.
That did change. The Loper Bright Enterprises versus Raimondo case said courts are no longer required to defer to federal agencies. So the rule had been under the Chevron case that when a law was ambiguous, a statute was ambiguous, and an agency had interpreted it a certain way, courts would defer to that agency's interpretation, assuming that the agency had more expertise in the area and was more given the responsibility by Congress. In addition, at the same time that courts have taken more power now to interpret statutes and regulations, they've also extended the deadlines. That's the Corner Post versus Board of Governors case. They've extended the deadlines by which you can challenge a regulation for being arbitrary and capricious, or for being, wrong in its interpretation of a federal law. So the statute of limitations now starts to run when an entity experiences the problem with the regulation. So that can happen anytime. And so that really has extended the statute of limitations forever. So this could, and I imagine it probably will, invite more entities to challenge the ADA regulations and the 504 regulations. There are a lot of good arguments against doing that. For example, the ADA has been reissued, it's been amended, and Congress didn't change anything to the regulations. So that indicates that Congress has adopted those regulations. So that's one reason why the lack of deference, that the courts should still have deference to those regulations, even if they don't to most regulations. And likely courts are going to continue to turn to agencies because courts just don't have the expertise themselves. I would say that entities that want to challenge the regulations, and especially in the web context, are going to be in a world of hurt, because then they have to come up with their own standard. And there is no other standard. So you're going to be paying experts to come up with more standards, and your litigation costs are going to go through the roof, while the plaintiff just gets to sit here and point to the federal government, which said, here's the standard. And by the way, the standard is a international consensus standard, and there is no other one. So trying to challenge the web regulations is going to be a bit of an uphill battle, and you're really going to have to get out your wallet.
And now we turn to the case that I think you can probably see if you look at the slide we had of reasons the cases are brought. And then you look at this case against the Los Angeles Community College District, really looking at, how is it that a couple of blind students, were unable to be provided with accessible documentation and course materials. They weren't able to access library resources, procuring and using inaccessible educational technology in the classroom. And really, this is one of those cases, I think, that it's come up several times and seems to keep coming back.
We're not going away.
And Eve, what's the learning out of this case from your perspective?
Well, the learning is make your stuff accessible. You've got to figure it out. And you can't just keep fighting and fighting and fighting. They could have made this stuff accessible already, I imagine, 5 times over with just what they've spent on litigating this case. This case has gone to trial twice now. Plaintiffs have won both times. Both times have gotten damages. The damages got reduced, but they've both times gotten damages. It's going to be appealed again. And I don't know if it'll require another trial again, but this has cost a fortune in litigation costs for the Los Angeles Community College District, and they still haven't made things accessible. So they are still harming these and other blind students in their education.
I was talking with
The
one
other
person.
big learning from this is that the judge in the first case issued an injunction requiring them to get it all made accessible within a year. So when you go to a judge and have the judge make the decision, you lose control of the timing for making your stuff accessible. If you hand it over to a judge who thinks a year is a long time, and a plaintiff who thinks a year is a long time, well, you may be thinking you can't get it done in that time. So making your own plan, letting folks know about your own plan, and actually following through on your own plan makes you more likely to avoid litigation, and it takes advantage of what you're avoiding in litigation, which is having somebody else to make your plan for you.
Talking with one person this past summer who had been a plaintiff in one of these major cases against a college, and she said, at the end of this, I got a legal victory, but I didn't get a great education. And I'm not convinced the students after me are going to get a great education either. And so I think that in addition to all these reasons, there's a real reputational harm that can be out there. People with disabilities are great brand advocates. I know I pay more to shop at some of the stores I do than their competitors. I also know that I get a lot of time savings by not having to have a whole bunch of accessibility workarounds at those stores. I'm willing to pay for it. I tell my friends to go there, but the opposite is even more powerful.
Yeah, and particularly in the higher ed space, people talk, and they talk about how you responded to them in terms of requesting accessibility. And not only people with disabilities and students with disabilities care about that, other people care about it too.
So the next case we were looking at was this Orozco v. Garland. And really the focus here was on a federal employee who had found some workarounds to use the technology that he needed to do his job, but that technology wasn't accessible. 508 doesn't say that you can buy inaccessible technology as long as your employees are tech whizzes who can work around all the accessibility barriers. It says we're going to buy accessible technology. And this case really was a precedential one in this arena.
Yeah, so this one, there was a question whether federal employees could sue their employers for using inaccessible technology that violated Section 508, or whether they were reduced to just the Section 501 reasonable accommodation approach. And this case said, no, federal employees have a private right of action to challenge their agency's use of inaccessible technology. Straight out, we don't have to go around asking for reasonable accommodations. If you have failed to buy accessible technology, we can pursue this case under Section 508 directly in federal court. So we're going to see, and we are seeing already, more cases filed under Section 508, both by federal employees, but also by people who just need to interact with the government. This has really, really pushed for greater attention to Section 508 requirements by the federal government, because they basically can't get away with it anymore.
Yeah, and speaking of 508, there was some work done this last year by the General Services Administration with the Access Board and the issuance of the Section 508 report. So if you look back to 2 Decembers ago is when we saw some congressional action on 508 noncompliance, and tucked into a giant omnibus bill was this little section that said, oh, by the way, the GSA needs to evaluate the accessibility of every agency's web presence and do that in a public way, do it yearly, and all these mannerisms. And I think it took a little while for everyone to realize what this requirement really meant. But by that spring, the GSA had issued to all the agencies, here's the form you're going to fill out. It's going to ask you all these questions about your site over the last year. And really, we expected this, but it proved that as a government, we haven't been doing so great on accessibility either.
That's right. It really reflects a lack of attention in the past to to accessibility and to 508 compliance. And just last week, Senator Casey introduced a 508 Refresh Act, which would impose greater, not requirements in terms of the outcome, but requirements in terms of the implementation. So really requiring agencies to pay more attention, requiring GSA to do more, and really putting greater emphasis on that we're not just kidding around. This wasn't just words on a page. These are real obligations. So I think that holds some hope as well.
And so, we see with that case in particular is that this idea that, if you're a supplier to the federal government, they're going to be reporting on how accessible you are. One of the questions on the form asked about photocopiers. Now, I can't remember the last time I used a photocopier, but if we're looking at photocopier technology, you can bet that we're looking at technology that involves instant messaging or the records or documentation and making that accessible.
Absolutely. So lawsuit lessons. If you haven't received a demand letter, lucky you, it may be only a matter of time. There are a gazillion websites out there, so it takes a little while to get to everybody, but some of the attorneys out here are trying to get to everybody. And don't wait for a demand letter. If you don't know whether your website's accessible, it isn't. And if you know it isn't, you need to be working on it now. You want to do this while you have the control over how and when you get it done. So litigation forces a rapid timeline. It's just going to not give you the time that you're going to want to get it done. It'll make it a lot faster, and it'll cost a small fortune to litigate while you're trying to make the changes. And then the Chevron doctrine may be over, but that does not mean that WCAG's not the standard. There is no other standard. If you're going to try and come up with one on your own, good luck to you. It's going to be really pricey to come up with that and then to prove that it's as good as the WCAG standard. And then I think real attention to Section 508, which is really going to put the spotlight on vendors, is going to be a big deal in the federal government. And that's going to have ripple effects throughout all tech everywhere.
And so as we conclude then with some key takeaways from our time together, we have some best practices for how organizations can mitigate their legal risk this year and into the future. Eve?
Well, don't wait. Time to start now. Time to start was yesterday. Get going and aim for conformance with the most current version of WCAG. So the Section 508 refers to WCAG 2.0. The ADA regulations and the HHS Section 504 regulations refer to WCAG 2.1. WCAG 2.2 is now going to be the most operable standard. These standards don't interfere with the prior versions, so you can implement according to the most recent version. That'll get you the most up-to-date accessibility requirements, and those will probably be adopted in the next round. Adopt policies and processes to prevent new accessibility barriers. This is not a one and done thing where you have an audit and you fix the things on your audit and then you're done. You keep adding things to your websites. Websites are dynamic. You've got to have, and you don't want to reverse engineer them. You don't want to, that's not what I mean. You don't want to fix it after the fact. You want to have it be accessible from the beginning. That's the cheapest way to do it. It's the most effective way to do it. Make sure that things are right from the beginning. It's the least dangerous way to do it. So adopt policies and processes and gateways or gatekeepers that prevent things from being posted without checking them for accessibility. Implement training for your technical people, of course, but also your non-technical people, the content creators, or the last person who touches the content, which may be an assistant. They need to know how to check for accessibility and how to make things accessible. That can save you a lot of headache. And then partner with experts and with people with disabilities. A lot of times we'll get, this is less now than it used to be, but experts who would go in with their expert assessments, but they didn't know how it worked in the real world. And so we would end up with things that were, quote, accessible, but not usable. They didn't make any sense. and then prioritize accessibility like you do privacy and security. It's going to be just as big an issue if it's not right as a privacy or security bug would be.
Yeah, I for a long time we've been saying that accessibility is like privacy, like security. You should address it early. You should make sure that you address it often, that it's something that is just core to the product. And really what we found is that a more secure and a more private product, also a more accessible product. And the same could be said in the opposite direction.
Right.
So some key takeaways then, and then we're going to get to your questions. So please continue to drop those into the Q&A box. It's clear, right? Digital accessibility is a legal mandate. There's so much to talk, and I think so often there's this distraction of like, well, what do the different circuit courts say? And is there a nexus between my physical location and my web location? Or, well, I'm this type of entity. I don't take federal money. You know what, it's going to cover you, if it hasn't already, directly. And especially we expect to see Title III regulations, which is private sector business, impacted just the same way that the Title II regulations are impacting state and local governments.
Yep, that's for sure. So the go ahead. Regs are getting stricter and more specific, and the deadlines are not long, 2 years and 3 years respectively. We're not waiting around.
And I think what's interesting is that so many of our customers are signing multi-year agreements with their partners. And so when they are then already locked in with a vendor, they're really struggling with, I've got 2 or 3 years. That might be the amount of time I have left with this vendor. And now I'm trying to bring somebody else in. I've already paid for a tool that I can't continue to use, that's inaccessible. But secondly, right, in the US and globally, these regulations, as Eve said, getting stricter, and these deadlines are fast approaching. Digital accessibility lawsuits citing the ADA are just so commonplace, they barely make the news anymore when these come out. And then organizations need to take an active effort to ensure that the experiences are accessible, no matter what legal action may come. That's definitely a risk that we're seeing organizations facing. So we'll move now to some questions that we have received. Quite a few questions here on higher education, and I wonder, Eve, would you be able to talk about settlement amounts, and what the payout for accessibility failings has looked like? And this person says that it's hard to find those numbers.
Yeah, it's really been all over the place. I've been looking at this recently, and the payouts run from the thousands of dollars to the hundreds of thousands of dollars. It's really going to depend how much you interfered with the student's education. So in education in particular, you do have an impact on education. If you've delayed someone's degree because they couldn't get accessibility and had to take courses over or skip courses, that's going to cost you. We do have the Cummings case, which came out of the Supreme Court, which said that under Section 504, you could no longer get emotional distress damages. So under Section 504, one of the calculations for damages was how much it affected you emotionally. That has challenged plaintiffs' lawyers to think more strategically about how they assess damages. But there are still educational opportunities damages if you messed around with someone's education. And that leads to years when they couldn't make the salary that they were going to be expected to make. That's going to be real damages. You can have opportunity damages in other ways, that people expected to have opportunities to gain from your website what others can gain from it. And those things will be thought of as damages. So the damages are really in flux right now, but they can range into the hundreds of thousands of dollars.
We got a couple of folks asking, a community college, in terms of the ADA Title II timeline, are they considered a special district?
No, they're not. A community college serves a local area, and so they'll be judged according to the population of their local area. Special districts are like public utility kind of districts. They're a very special thing.
Special indeed. We got one about, are US universities, would they be considered to be doing business in the EU? at least from my perspective, Eve, I'd love to hear yours. I would think that there's a leap that could be made, that you're making information available, and I, as a European citizen or resident, am making decisions about where to spend money, ergo commerce. It's not directly called out, but it certainly seems like it could be a logical leap, without too many steps in between.
Yeah, I really don't know the answer to that. It could certainly seem like commerce into the EU, but I'm not sure if that's how the definition works. I would have to look that up.
Yeah. We got one, and I think this would be one I'd love to hear your thoughts on too, Eve. Are there definitive resources to help present the legal seriousness of the business to the business community? This person says they're having a hard time getting through. People just see this like search engine optimization or something like that. We'll get around to that. And certainly we've put out some content on our website about why digital accessibility or why now, a couple of resources that come to mind. We've got our legal intelligence report, some of our proprietary data that just came out a week or so ago, summarizing a lot of the information that we've covered here in this webinar, but also really more in detail on that first quarter of litigation. But what do you think, Eve? What do you find has really moved a business leadership to make this accessibility a reality?
Yeah, I think one of the things that moves business leadership is DOJ settlements that do have damages amounts in them. And the problem is you can't tell how much the entity spent getting to this place. And that's one of the things that should get people's attention, that you may have paid $50,000 or $100,000 in damages, but you also paid gobs of money in litigation fees. And that's the real hidden answer. I think what everybody needs to do is have me come talk to them. I'll scare them.
You're so friendly, Eve. I'm the friendliest lawyer I've met. And then again, I'm usually on your side, so that helps.
That's right.
We got a question here with regard to Title II. When and how is enforcement going to happen with those new regulations?
So enforcement under Title II is both through the private sector and through the federal government. So the Justice Department enforces it, but private individuals get to enforce it as well. And it's not going to not be enforced for the next 2 years while we wait for the regulations to kick into effect. The Title II entities are already covered under the ADA and already have to meet the equally effective communication standard, which doesn't specifically require WCAG and notably doesn't give you the exceptions that the new reg gives you. So I would not rest assured that there'll be no enforcement for the next 2 years. After 2 years, then there will be a good deal of enforcement, I think, because it will be quite easy to tell that you haven't complied with WCAG, and there will be no dispute about what the standard is. But I think I wouldn't be too sure that you're not going to get any enforcement for the next 2 years either. And the Justice Department has been quite serious about its enforcement in the web space, and the federal agencies like the HHS, the Department of Health and Human Services, have been quite serious. Department of Education also has been quite serious in enforcing web accessibility requirements. And I think we'll be doing so for the next 2 years, in addition to after the regs kick into effect.
We have a question here about the responding to demand letters that you receive and the ideal response. And we get this one a lot. Does responding open me up to more liability? Am I admitting that my culpability and continued knowing about an inaccessible website?
We already know. So it actually helps us be patient to know that you know too. So the perfect response to a demand letter, I'll tell you the response to a demand letter that I hate to get is the response that says, you are so right. Here's our analysis. Here's what we're doing. Here's our plan. The thing that you've raised, we're now going to prioritize that higher just because you raised it. But here's our plan that's already in effect to get this thing done before you have time to sue us. That's the perfect response. So that leads to our previous tips, which said, get started now, have your plan in place now, be effectively implementing it already. That's what discourages litigation. And then bonus points for telling people about your plan, because then we're more likely to be patient. We're more likely to see, well, I can't get this litigated in the time they're going to get it done. So I'm going to let them go. I'm going to move on to the next guy who doesn't seem to know that his website's inaccessible.
Yeah, and even outside of formal legal complaint letters, one of the things I've long advised our customers to do is, when you get accessibility feedback, don't send back a generic, thank you for your feedback. We value everybody. We don't have time to respond to anybody, go away. But really to come back and to really take that opportunity to double down with that user. I point to a few organizations that really come back and say, Apple is one of them, Target's one of them, Slack is another, right? They come back and they say, we've replicated this using our assistive technology. Here's what we ran into. We're curious. Our team is looking at two options to solve this. Which of these works better for you? We're not going to commit to when we're going to do it, but we understand the issue. Remember, I have no interest in, as a person with a disability, and most people don't, in suing anybody. I don't get pleasure out of that. What we'd rather do is have, just a discussion and say, hey, as a user, this is what's important to me. And by the way, your website that constantly won't manage focus or where things aren't labeled, it's really no different than a flickering screen or a crashing browser. For me, in terms of my ability to use it. So we're just looking for that prioritization decisions and really knowing that you understand what your users are experiencing. We got one here. If someone were to start at ground zero and prioritize the work required for the WCAG standards, is there value in prioritizing those based on the likelihood of being brought into a demand letter situation? I think that certainly we've talked some about the basics are the ones that everybody's still focused on. Alt text, color contrast, form labels, hierarchy of information, that's headings and regions. These are really the easy things to work on. And I think that certainly there's a level of prioritization, not because those are the first ones that you would get sued under, they are, but because those are the ones that at level A in the success criteria, we're saying as a community, these are the ones that impact the most number of people. If your website's not usable with a keyboard, it's probably not all that usable with a screen reader or with a dictation software. If your website doesn't work when I magnify it, it's probably not going to work that well for somebody who's colorblind. So these are the kinds of requirements that we look at an early stage. And so that prioritization is helpful. And certainly one of the things that we help folks do is prioritize based on the severity of the blocker for somebody with a disability. But naturally, I think those pair very directly into the things that you often see in settlements and in demand letters. We had another couple of questions on higher education, Eve. Do learning management systems and the information included in them, like a Blackboard or a Canvas, does that fall within the requirements or exceptions for Title II?
Yes, it very clearly and specifically falls into the requirements. They have to be accessible.
And
the content on them has to be accessible as well.
There was some talk initially when those regulations were first put out for public comment that said you didn't have to make your course content accessible unless it was requested, and then you had to do it within 5 days.
Right.
And glad to see that exception was removed, just because we all know that if you think 1 year is going to be a tight timeline to make something accessible, imagine 5 days working with professors, no less. They are very much not the folks that are probably building the interactive course content that they've been using for the last several years.
Yeah, that proposed exception didn't work for anybody.
I think the last one we have here is maybe a couple more after this. My understanding is that public colleges and universities, they're legally accountable for accessibility of the products they choose to purchase through vendors. How does the California AB 1757 change this?
I don't know. That's a good question. I don't think it does change it. I think you're still responsible for the vendor for what you use from your vendors. I think 1757 just also provides a cause of action against the vendor. It's an either or and.
I think what that law is more giving you is giving the universities a course of action when, you know, they purchased something thinking it was accessible and it was not, or they were told it was and it wasn't, giving them some recourse more so than changing any of the federal standards for
Right.
sure. Sorry, I missed a couple here on social media. How far back should social media content be made accessible? You know, I think what I would be looking at is, you know, technically it's about when that your particular municipality falls under the ADA Title II regs, you know, whether it's going to be 2 years or 3 years, but really it's about what's the definition of archival content. And so many times I get questions like, well, we have this, is this an archive? We haven't touched it, but people use it. Well, kind of inherently not archived if people are using it or reading it or using it on a regular basis, right? So it may have been created in the past, but if it's still being used, it's something that somebody with a disability is going to want to have access to. And then as it relates to when we'll see 2.2 become part of these regulations, you know, a couple of years ago, we were saying, you know, 2.0 is the standard. I don't know if we're going to get to 2.1, but certainly within, you know, just about 5 years, we got there. And so I think that it's worth looking at these standards as this is an international body that has met with a group of users, made some determinations about what's accessible and what's not. And they're saying, as a group, CAPTCHAs are challenging, even with audio, even with video. So let's talk about some ways to work around those for all users, not just those blind users. We've got more questions than we can answer here, but I tell you what, we will commit to looking at these questions. We'll send you a reply if we didn't get to your question, and we look forward to continuing the conversation. In the meantime, we're going to put up our contact information here on the screen for myself and for Eve. I am corb.o'connor@levelaccess.com. And Eve?
And I'm E. Hill at browngold.com.
And we appreciate all of you so much for joining us on our webinar today, really looking at how those lawsuits and laws and learnings are shaping compliance in 2024. Thanks for joining. And thank you, Eve.
Thank you. Just happy to be here.